that there has to first be an acquisition of the property, because 39B deals only and only with distribution. It cannot be used in aid of statutes where the property of a private individual is being acquired.
Actually, Ms. Shukla, the philosophical approach of both Justice Krishna and Justice Chinnappa Reddy is this. If you look at the purely capitalist concept of property, the capitalist concept of property attributes a sense of exclusiveness to property. This is my pen. It's exclusively mine. Nobody else can use my pen. The socialist concept of property is the mirror image which attributes to property a notion of commonality. Nothing is exclusive to the individual. All property is common to the community. That's the extreme socialist view. Our directive principles, we must understand, have their foundation in the Gandhian ethos. The directive principles are really in pursuance of the Gandhian ideology. And what is that ethos? Our ethos regards property as something which is held in trust. We don't go as far as to adopt a socialistic model that there is no private property at all. Of course, we have private property. And that concept of trust, which is now being applied, in the context of, say, sustainable development, in the environmental context. Maybe it's in my mind because I was teaching a class this morning on sustainable development and climate change. But, our concept of property has undergone a very subtle change from either the extreme capitalist perspective or the extreme socialist perspective. We regard property as something which we hold in trust. We hold the property in trust for the succeeding generations in the family. But broadly, we also hold that property in trust for the wider community. That's the whole concept of sustainable development. That property which we have today, as today's generation, we hold in trust for the future of our society. That's what you call as intergenerational equity, right?
Yes.
So, it would be, to my mind, it would be a little dangerous to have this dichotomy that 39B only. Now, one more thing before I come to it, because I'm sorry to break your link, but I'm getting old and I might miss this, half an hour later. See, both Justice Krishna and Justice Chinnappa Reddy deal with two aspects when they deal with 39B: the origin and the beneficiary. The argument before the bench in Ranganath Reddy was that the origin must be in the community for 39B and C to apply. If something does not originate in the community, then 39B can never apply. Second argument was that distribution postulates that you will distribute it to individuals. If you're not distributing it to individuals, then 39B will not apply. They deal with both these arguments at a philosophical level by saying that even if something does not originate in the community, right, if it is property of the nature which has a bearing on the welfare of the community, 39B is capable of application. Second, that is the origin. On the distribution, they say that even if it is not being distributed to individuals, for instance, nationalization, you take over property, vest it in a state corporation. It's not a distribution to an individual. That concept is also within the purview of 39B. Because why were you nationalizing? You were taking over private property, but using that property in trust for the wider society, but it is not being given, it's not being distributed. So they deal both with the source or the origin, and they deal with the distribution aspects in these two judgments. It may be a little extreme to suggest that material resources of the community only means resources we do not have their origin in the private property of an individual. I'll tell you why it will be dangerous to take that view. Take simple things like mines, forests, even private forests. For us to, for instance, say that, look, the moment a forest is a private forest, 39B will not apply, would be, and therefore it's hands off, would be extremely dangerous a proposition. It depends upon context. As Brother Dulia said yesterday to us when we were discussing on the bench, it depends on the context. In a given case, a private house,
Zamindari land.
Yeah, exactly. Zamindari lands. That was the whole basis of our agricultural ceiling laws.
Yes.
Whether it was the UPZA and LR Act or the Maharashtra Agricultural Ceiling on
Yes.
Agricultural Lands Act. So we must have regard to, we must put ourselves back in the 1950s when the Constitution was made. So the Constitution which was intended to bring about a sense of social transformation. And that was the transformative ideal of the Constitution. Whether this act is valid is a completely different issue.
Yes.
Is a completely different issue. That will ultimately be decided. But we can't say that 39B has no application once property is privately held property. Because the societal demands, the societal welfare, the need for redistribution, considering the societal perspective. So it may be airwaves, it may be water, it may be forests, it may be mines. In some areas, probably the dividing line becomes very clear. Just taking somebody's flat. Possibly, you may have a point on that. But we must understand that 39B has been crafted in a certain constitutional ethos. That the Constitution was intended to bring about a social transformation. Therefore, we shouldn't therefore go as far as to say that the moment private property is private property, that 39B and C will have no application.
So, Lordships, may I just...
The second thing which I wanted to tell you was that whether 39B and C can have two consequences in our constitutional law, right? One, the moment a law is enacted to give effect to 39B and C, that law is immune from challenge under Article 31C, unless you come to the conclusion that the law has no nexus to 39B and C, which was what was struck down in Keshwan and Bharati. So the moment a law is in furtherance of 39B and C, that law has an immunity under 31C. But even if the law does not have an immunity under 31C, right? Even if the law is not immune from 31C for some reason, say some bench comes to a conclusion that 31C does not exist on the statute book today. Even so, the fact that the law has been made in pursuance of 39B and C may be an index of its reasonableness. That's not just 39B and C. The fact that Parliament or the state legislature has enacted a law to give effect to any of the directive principles is an index of its reasonableness. But reasonableness postulates that it's subject to or amenable to judicial review. What 31C did was, it completely excluded from judicial review on grounds of 14 and 19,
Yes.
leaving open again now other constitutional challenges.
Right.
So I think that's where the matter really lies in that sense.
So, Lordships, I'll just...
Today, Mr. Andarjuna didn't argue on 31C. We'll ask the other side when we are on 31C, because one thing which we are thinking aloud, actually, not just for you, but for the other side when they take up their view. The argument that this law has no nexus to 39B and C, right, postulates that 31C is valid, because that whole argument that the law on your side, that the law has no nexus to 39B and C, postulates that because it has no nexus to 39B and C, therefore the law is not protected by 31C.
Yes.
Which means that 31C is there.
Exactly.
But because the law has no nexus to 39B and C, therefore this law is bad.
Yes.
Right? But if 31C does not exist at all.
Absolutely.
Right?
Yes.
Then the 39B and C argument will still apply.
But independent of 31C. Yes.
On the ground that the law is not immune from challenge under Article 14 and 19.
Exactly.
But the law is presumed to be reasonable because it is giving effect to 39B and C. There are two different things. One is an immunity from constitutional challenge. The other is the index of the reasonableness of the law.
Absolutely.
So I'm subject to hearing the other side. Now, one last thing, Mr. Attorney, Mr. Solicitor and Mr. Dwivedi, look at it this way. The 31C argument, the 31C argument, there are succeeding constitutional bench judgments of our court which have taken the view that 31C still continues to exist. Minerva takes it, Vamanarao takes it, subsequent decisions have taken it. Though Mr. Nariman argued in the referral order
That it's on a
this was only
concession.
on a concession.
Yes.
That this was on a concession.
Yes.
Now, therefore, that 5, the correctness of the Constitution bench implicitly holding that 31C still continues to be on the Constitution. The correctness of it, if it has to be tested, which was what Mr. Nariman argued, will have to go to 7. We'll have to go to 7 judges. 9, the reference to 9 came only because of Ranganath Reddy,
Yes.
Justice Krishna's judgment, which was then adopted in Sanjeev Folk. Therefore, the bench felt, let's go to 9.
Yes.
But even if we don't go into 31C, 31C will have to be decided. Whether
Yes.
31C is on the statute book will have to be decided by a bench of 7 judges.
Yes. Absolutely.
Now, the question is whether we should leave it for a future day for some 7-judge bench to decide it, or decide it here, because we are certainly a bench of 9 can certainly decide it. Why leave the law in a state of uncertainty?
On our side,
Because
speaking
75
for
years
myself.
down the line, for this court to say that 31C does not exist
Yes.
will be a very radical constitutional consequence. So all the laws which have been protected under 31C will become vulnerable. Therefore, instead of leaving this to a future, litigation before 7 judges, you may also reflect on it that perhaps we should resolve it and put,
We're open. We're okay with it. Before
There's a
that.
request.
may have to hear them on the 31C argument, and we'll allow you to respond to it, because leaving things in constitutional uncertainty is also not good thing for the nation.
Reflect and respond. My immediate response is, there is no uncertainty about 31.
We have 5 judges have held, though according to Mr. Nariman, as he then Mr. Pari Nariman,
Yes.
that this was on a concession.
But it is not so. But be that as it may, nobody has doubted 31C now.
If it is not so, then is it not really desirable that a bench of 9 should put an end to this controversy? Because otherwise what happens is a whole host of laws become just vulnerable to challenge. We are not concerned about the merits of this law which is in challenge before us. That's the least bit of a problem, the least bit of the worry. Whether this law is upheld or struck down does not really, in that sense, alter the nation's constitutional fabric.
Correct. My Lord, what possibly, my Lord, Mr. Nariman also argued, and what was the point in controversy was not whether 31C survives or not. The question was, partly 31C having been set aside, whether there would be a revival of what is already gone. That's all.
That's the point.
That's all, not the validity of 31C.
The revival. Because what happens is, 31C in Keshwanand Bharti is struck down, only the last part is struck down.
Correct.
Yes.
Which said that whether the law actually gives effect to 39B and C would not be inquired into by any court. That was
So
the latter part.
judicial review was taken away, which is settled.
Keshwanand Bharti said, no, that part is unconstitutional. Whether the law actually gives effect to 39B and C is reviewable. So Keshwanand Bharti strikes it down. Therefore, the substantive part of Article 31C is upheld by Keshwanand Bharti. Now, what Parliament did was in the 42nd Amendment, they expanded the ambit of 31C by including not merely a challenge on 14 and 19, but on all the fundamental rights.
Part 3.
Right?
On all directive principles. Instead of only
directive
39B and C.
On all directive principles, right? Instead of 39B and C, they said all directive principles. That is struck down in Minerva Mills. Now, what is the consequence of the decision in Minerva? Does that only strike down the expansion of the ambit of 31C to all directive principles?
Yes.
Or does it leave intact 39B and C? Now, if your contention is the latter contention,
Yes.
39B and C, it still continues to be valid. But is it not important that we deal with that and decide it?
But the difficulty is, my Lord, neither anyone has addressed, my Lord, that your Lordships can permit addressing. We have also not, my Lord, examined from that point of view, my Lord. Because according to us, my Lord, and at the outset I pointed out that the controversy before this bench is limited.
But what's going to happen is this will go back right away before 7 judges to argue that. And what we are doing is, We are dealing with the offshoot, namely 39B and C,
Yes.
without dealing with the mother, which is 31C.
But
If 31C, if they are right, for a moment, hypothesis, if they are right that 31C does not exist on the Constitution today by virtue of the judgment in Minerva Mills, then whether the law is protected under 31C as giving effect to 39B and C does not arise at all.
correct, my lords, but nobody has doubted that proposition, which may, my lord, give rise to a re-examination by the larger bench.
The first referring order specifically raises this as Mr. Nariman's argument. In the second and third referring orders, what happened was the focus shifted to
39B.
39B and C. But the fact that Mr. Nariman, and he's observing us from heaven, the fact that Mr. Nariman raised this issue about 31C is squarely a part of a referring order. And that will have to be decided by seven judges at the minimum.
Five.
Decided by
It-
seven.
Five.
One can also
Five,
decide-
five, my lord.
No,
Five.
it has to
Seven.
go before seven because it has been decided by five.
It is three.
By a
The
bench of
first
five.
reference is three.
No.
Minerva Mills is five.
Minerva Mills is five.
Minerva Mills is five.
Minerva is five. Vamanarao is five.
This is the first question.
This very question has been referred by 5 to 7.
My sister just Nagaratna, with her permission, I'll just read out. The first question which Mr. Zal had raised yesterday was whether 31C of the Constitution survives after the judgment of this court in Minerva Mills, reported in so and so, striking down Section 4 of the Constitution, 42nd Amendment Act, 1976. Briefly, what they are arguing, they're not saying that they are right. They say that when a constitutional provision is substituted by a constitutional amendment, and that substituted constitutional amendment is struck down, that does not result in the revival of the original provision.
Yes.
Your answer to that would be, and I presume it, we have not heard you, is that when a constitutional provision is substituted by another constitutional provision to expand the ambit of that constitutional provision, then the striking down of the subsequent constitutional amendment on the ground that the expansion was unconstitutional.
The remaining part
Will
remains.
not affect the original. It will not be, because this was not an absolute substitution. This was an expansion of the ambit of the protection which Article 31C gave. And the original provision having been upheld in Keshwanand Bharati, surely the impact of a subsequent smaller bench of five cannot affect the validity of the provision in Keshwanand. That's your argument. That's the point that we have to deal with. But, honestly,
It was our argument, presuming 31C to be the subject.
Yeah, because on your argument on 39B presumes that 31C is valid. Now they are raising an issue that 31C is not valid.
No, they are raising, my lord, but the court has never, my lord.
I agree with you.
Your lordship, my lord, I can
But
say one
the
thing.
first referring order itself refers to this.
But my lord, thereafter that is given up, my lord, by every larger benches. Your lordships, my lord, sitting in this combination,
Given up, actually.
my lord, your lordships, in my lord, one line answer, in this combination, your lordships can take up, my lord. I am not on that technicality.
Even if the Attorney General or the Solicitor General is to say today that he is still there, there would be a question by somebody, as was done, that it is a matter of concession. So should there not be a clarity on what is a very significant part of the Constitution?
No, let us, my lord, have, my lord, the
One thing, of course, the other side, as the Chief Justice has rightly said, they have not had the opportunity. In fact, the discussion which is emerging today might have taken them by a bit of a surprise. So I think that will have.
all of,
Actually, what happened was yesterday.
One more thought.
Yesterday, Mr. Andarjuna was ready on 31C. Mr. Devarajan was to argue 39B. We tell, and Samir also. We told them that we are not going into 31C.
and my lord, we were, and my lord, I'll just
the cat
add.
among the pigeons yesterday, you see. So that's why they were.
My lord, and I would add, we were ready to persuade your lordships that 31C does not arise, and we could.
Mr. Solicitor, we are more than willing, amenable to persuasion that, look, 31C does not arrive.
No,
That
it's
the argument of Mr. Nariman in referring order 1, there's no substance in it. Please don't, but then we can at least say, if you're right on that, we will say that the continuation of 31C is now a concluded doctrine in our jurisprudence, so that we lay it down for the future, if you're right. That, 31C, that there is no though it was raised by Mr. Nariman, and that was the basis for one of the reasons for referring it to bench, a larger bench, and referring order 1, that there is no substance in it. And then, that attains finality unless somebody decides to refer to
My lord, can we, my lord,
for it,
First part of.
One
which
thought.
can we respond, my lord, after consulting?
In which case, after we've heard your submissions on 39B, we'll hear them on 31C. Mr. Andarjana has broadly argued it. And then we'll hear him, intensively for a couple of hours and hear your response on it.